We're live. Okay. Well, welcome, Judge.
Thank you.
Judge Glenda Hatchett is here, and I have so many questions.
Okay.
But
let's
talk first a little bit about you. When you were a judge, tell us where and on what court.
Yes, I was a judge. I was the chief judge of the juvenile court in Fulton County, which is Atlanta and 9 other municipalities. Mm-hmm. One of the largest juvenile court systems in the country. Urban community, high crime rates at the time. A lot of things were going on, not just in Atlanta, but nationally. So,
we talked about, you being on the bench.
Yes.
And before that,
yes,
you were a busy lawyer,
right,
representing in-house counsel for a big airline.
Yes.
Right. And then after you went off the bench, you then have had a career as a judge on television.
Yes.
Right. So I raise all that because
right.
You are the best person I can think of a lawyer asking a judge who has a lot of experience what you like when you saw lawyers in court, what you didn't like, some techniques on how we can become more persuasive.
Okay, let's talk about that.
So let's start with the positive.
Okay, can I give your listeners though a little bit of context?
Sure.
They'll say, well, wait a minute, she's a TV judge. How does she know this? So, to your point, when I finished law school, I clerked in federal district court in the Northern District of Georgia. At the time, there had never been a black clerk, man or woman. So it was a very interesting kind of time in my life. I went there, from there to Delta Airlines in-house counsel. At that time, Mike, I was the highest woman of any color, black, Hispanic, Asian, any color worldwide. And unlike a lot of in-house counsel, we actually tried cases. Mm-hmm. We would have local counsel, but we would actually try cases. So I would go and try cases in federal court around the country. Everybody thought I was crazy when I left that job to go to the bench. So you're right. I had the perspective of in-house, bench, practicing lawyer, being on TV as a judge, having my own law firm. So shoot, I wanted to talk about this. And I just want
to say, as a trial lawyer, having you co-counsel a trial is a dream, and I hope that we've got a few things in the pipeline.
Yes, I'm looking forward to it. I cannot wait because you know what, I have such respect for you. I really do.
Thank you.
Yes.
So let's talk positive.
Yes.
What were some of the positive, good things that you've seen lawyers do that you found effective or persuasive?
Right. The first thing is that you have got to establish credibility with the judge, right? If you come in and you are on that gray line, don't do it. Don't do it. I had an internship with the mayor in Atlanta after my first year in law school, and he had this saying, if you get close enough to the sideline and you get chalk on your cleats, even though you don't cross it, you're too close. And so what I tell lawyers is that you have got to be very credible with the judge, because if you lose that credibility, it's really hard to get it back. So be prepared and be honest that if there's something that just didn't go quite right and you need a continuance or whatever, say it. Be honest about the reason for asking for that continuance.
So no excuses. Mm-mm. Own it.
Own it. Own it.
And how important is it? I've always found this, that I thought this was effective and important, that you argue the points that you can win, and the points that you shouldn't be arguing, you concede.
Yes. Oh my goodness. Let me tell you. And that will get you so far with the judge. If you know that there's something that's not quite right, you concede it. You concede it up front. And you are the one who wants to put the bad stuff out. You don't want opposing counsel to do that. I mean, you want to, as you say, own it, but you also want to be the first person to broach that. You don't want them to say, because then it looks like you were shady and trying to hide some stuff. Other thing is, come prepared. Come prepared. Don't half step, because it will come back and bite you in the behind.
And what are some things you've heard that lawyers say that they're not prepared? Like, well, I got to talk to my associate about that, or other.
Right. Or judge, let me go back and check my notes. Right. I hate that. Right. I'd rather you say, listen, Your Honor, I need a recess. Let me go and check. Don't sit there fumbling. And for God's sake, don't make up an answer, because if it turns out to not be true, you're going to look crazy. You're going to look crazy to the judge. You're going to look crazy to your client. You're sure going to look crazy to the opposing counsel. And if there's a jury, they're going to be looking at you like you're crazy. But come prepared, and don't sit here and then sit there and try to brief your client on stuff that you should have already prepared them for. Right? And the other thing that I think that lawyers make a mistake in, Mike, while I'm thinking about it, is that you need to tell your lawyer, don't keep interrupting. Tell your client, don't keep leaning over and interrupting you. I tell my clients, now look, once we get in the courtroom, don't pass me 500 notes, because it looks like I'm not prepared. And half the time, the client's not going to know that the notes that they're sending you are worthless. But it's also a distraction.
Boy, I've told that to my clients in trial. So I'm like,
yes,
I get it, but let's wait for a break. And then you can give it to me, right?
Right. And then, they want to whisper something. Don't let your clients whisper to you in the courtroom. Make it very clear that they have to wait to the break. So, of course, you want to give them an opportunity to speak to that. It's very distracting, but very importantly, it looks like to other people that you may not know what you're doing. And that's not the case.
So how important is it to be respectful, not only to the court, of course, but to opposing counsel?
Let me tell you, if you get in there and you want to be a jackass to the opposing counsel, that's not going to go over well with me on the bench. It's just not. I need you to be respectful. Obviously, you're going to be respectful to the court. But even if you have to swallow hard, I've had to do that. I've had to swallow hard. Except I did lose my temper once when the guy told me that I had lied, and then I jumped up. I mean, before I knew it, I was out of my seat, and I'm like, Your Honor. But I've had, only in my career, I've had one person where I just really, but I had to sit there and, I say, yes, counsel, yes, Mr. So-and-so. You have to not show that you're angry, because once you do that, you lose your advantage.
I've sat in the back listening to so many arguments.
Yes.
Learning. Mm-hmm. And I never forget the lawyer who talks about the opposing counsel when the judge says something like, well, counsel, you were late today. And then the other side goes, Your Honor, they've been late to every appearance.
Isn't that crazy?
Your Honor. And then it's almost like
tattle and they don't let it go. They don't let it go.
And my first instinct is, one, why are you doing that? Two, you're losing credibility. And three, you're not focused on the ball here. Right. And I think that comes across.
I do too. And I also think that what they're doing is they're trying to really kiss up to the judge by saying, I'm really great. I was here on time. He's never on time. She's never on time. You're right. And if you start, my theory about this, Mike, is that if you start looking over your shoulder and doing all that craziness and just getting distracted, then you can't be focused fully on your case, and you can't be focused on your client and the examination you've got to do with this person who's on the trial. And don't let witnesses rattle you. See, that's another thing I've seen. They hate the witness. They hate the witness. The lawyer hates the witness. And it shows. You can't do that. You got to remain calm, because the minute you lose your temper, you're calm, you're distracted, but it also signals to the judge that you're out of control.
Interesting. I was on another podcast episode, I talked about negotiation, and I was reading Chris Voss's Never Split the Difference. Mm-hmm, mm-hmm. And he's like, how do you be a good negotiator? Number one, don't lose your temper.
Don't lose your temper.
Right? And isn't that the case about heartbeat control and keeping your temper in control is 98% of what you need to listen, to focus, and to act, right?
Right.
And when those things come in, that client who's whispering, you can't hear a doggone thing they're saying. You're right. You are in free fall.
You've got to be, you've got to be laser focused. The other thing too is, and I admit that I've been in mediations where I've lost my temper. I have. I mean, I admit it. And as soon as I realize I'm there, I'll ask for a break, and I'll go and I'll walk around or whatever, because there are people who really are out to push your button. Don't let them push your buttons, because once that happens, it's exactly what you're saying. Just things start coming apart. But what happens is that if your opposing counsel is acting the fool and you're steady, that's going to go over well with the judge, and particularly with the jury if you got a jury trial.
Now, on positive things that
Yes.
help, how important, if at all,
Yes.
was it for you, is it for you, that in the preparation of counsel, when they cite a case that's not in the ordinary, that they have a copy?
Please. Oh my goodness. Oh, that is very helpful. And in our pretrial conferences, what I very much appreciated was lawyers who would do that and would have those cases for us, even at the pretrial conference.
With jump sites, with not just
Yes.
the front page, but the
yes.
relevant page.
Yes.
And
Yes.
how important is it to have properly marked exhibits or highlighted?
Oh my
To me,
goodness.
this just, if you come from a perspective of, in anything that we do as lawyers, from settling a case with an adjuster or a defense
Yes.
lawyer to a judge, the easier you make it for the other side, the more effective you will be.
Exactly. There have been too many times when they have said, okay, we're going to submit these. There's going to be stipulations. Okay, so we know that we have exhibits that are stipulated to, but then obviously in every trial, there are going to be some things that are going to have to come in at the time of trial, right? And you don't need to be fumbling. And please, if you're using technology, ask the court, can you come in at a time when the court is not being used? Make sure that's going on, even the morning of. I always get there early. Get there and make sure that works, because I have seen people come into the courtroom and then the technology doesn't work and they're standing there fumbling. Well, that's not going to be all right. That is not going to be all right.
Right. Point in case, if you're using a PowerPoint, print it out.
Print it out.
Because you always have an Elmo backup.
And
you
give it.
can put it up on the Elmo.
Right. And then what I have done is, when I've had PowerPoints, what I've done is I printed it out, to your point, but I've also given it to the judge.
Yeah.
I've given it to the judge because a couple of things, right? I want them to be paying attention, but I also want them, if they want to go back and flip back through it, it's really wonderful. Obviously that stuff is important and tools, but you have got to know your exhibits. You've got to know where to find them. If something comes up, if you get up on redirect and you need to pull something to really, what's the word I'm looking for a witness?
Impeach them.
Impeach them. Thank you. That's the word I'm looking for. Impeach that witness. You have got to know, and where organized trial notebooks, you got to know that if he says or she says something, I know I've got a whole little section here that I have my arsenal for impeachment. And so I know exactly what I'm going to pull. I'm going to go back. And you don't necessarily need to be taking copious notes, but it is helpful to have somebody at that table take some notes. And if it's a really in-depth, lots on the line, get daily take-backs printed to you, because you want to look at those things before you get up and start the next day.
So now let's switch gears to things that aren't persuasive,
right,
that aren't helpful,
right,
that maybe are not looked upon well. And I want to start with something I tell everybody from start to finish, young, old.
Yes.
And a lot of younger people don't know the expression, don't gild the lily.
Oh, right.
And they're like, what do you mean? And I'm like, well, a lily is a beautiful flower. And if you gild it, you cover it with gold, but you kill the flower. And the idea of trying to make an amazing thing even more amazing, a lot of times, they change their testimony. You lose that beautiful testimony. Have you seen that?
I have seen that. It's, I've also seen, to that very point, Mike, and I mean, you're the expert, really. You have taught so many classes and you've been such an inspiration to so many lawyers. What I've seen too is that there are lawyers, that whole thing about the lily is so right, but lawyers who then try to stretch the truth. Right? The facts stand on their own, but somehow in their minds, they think if they can just, stretch it. And I've seen lawyers stretch it to the point where it's no longer credible. And that is a major, major, major problem that happens. If the facts are the facts, stick with those facts. live with them, as we talked about earlier, and can see the stuff that doesn't work for you. Yes, there was marijuana. Yes, he was driving, but yes, the tractor trailer then came and T-boned him, but he didn't cause the accident. It's a wrongful death thing. The fact that the toxicology, yes, there was some marijuana.
Mr. Expert, we agree that there was marijuana in the car, right? We agree that he was speeding a minute before the incident. Yes, we agree on a lot of things. Now let's talk about the things that are relevant to this case. Right. Not fighting all that. But when I hear a lawyer in deposition or trial do a great cross in depo or trial, and then they go, so let me summarize. I'm like, no, don't summarize, right? Let me just make sure that I'm crystal clear on this. Stop it.
Stop.
You are asking for a crystal clear testimony for that witness to go, well,
now that I thought about it.
Right? All the time.
Now that I thought, well, you know what? Actually, Mr. Johnson, now that I think about it, I really think that, listen, if you're ahead, but that's what lawyers do. I mean, we want to just go that extra piece. Stop while you're ahead.
As an aside, I also, whenever they take a break or whatever, I'll very quickly, when they come back on, I'll say, hey, is there anything you want to change, add to your testimony? And they mostly go, no. And so then if later they're like, well, you didn't give me, I'm like, look, I asked you if you wanted to change your testimony.
And you said
3 times in the depo.
Right.
Maybe the difference is you had a chance to talk to counsel.
Right.
Any other really...
Are you afraid now?
Yeah, exactly.
Are you afraid? Are you thinking about this? Did someone intimidate you? Are you afraid? Did anybody talk to you about this? Mm-hmm. Now, when I ask you, has anybody talked to you about this testimony? You told me no. Now, what happened there? Yeah.
I just took a depo yesterday where an expert had a billed for a 1-hour consultation with defense counsel. And I asked him, what did you talk about in that 1 hour?
Yeah.
He has no recollection.
None?
0. Counsel, I didn't even know I talked to him until you raised that issue with me. I'm like, okay, whatever.
And then you have to stop.
Right.
That's where you stop.
You say, you knew that I was going to ask you about that, right?
Right. So then if he can't remember, then he can't be an effective expert witness at trial.
Exactly.
And so why are you going to give him a chance now to undo? I mean, you got to stop. Because then the tendency is that people will say, well, now, Mr. Expert, come on. You were there for an hour. You don't want me to believe that you didn't remember. If he says he doesn't remember what he talked about, how can he possibly be an expert at your trial?
Totally
he can't
agree.
be. And just stop.
So I see, what we're talking about are basic techniques, basic things that are persuasive, speaking in an authoritative, positive way of saying, instead of, well, Your Honor, I think what he said was such and such. Right? No, Your Honor, he said X. Right?
Right.
It's my opinion that the defendant was negligent. Your Honor, the defendant was negligent. Just that change in language.
The language
is so persuasive.
So important. And your body language is important. When you get up, you have got to own the room.
Absolutely.
I've seen too many lawyers get up and they stand up and they stand at the podium and they do the opening and they're almost reading it. You have got to know the facts. You've got to tell the story. What is the theme of that case? Premises liability case, good example. The theme is simply that they put profits over people. And that's what I kept saying. They put profits over people. There was not security in the parking lot. The client was sitting waiting for his order.
Now, if you can watch this, look at the judge with her finger.
Yes, right?
Point.
Yes, right,
point.
Right. And then what you want to do is that you want to paint the picture. You're not trying to win the whole case in opening. Lord have mercy. You're just trying to say, and if you say in opening, I am going to prove this, you will see at trial, ABC. You better damn be well prepared to do A, B, and C. And if you can't, don't go off on a tangent in opening, because it'll come back and bite you. And I've seen that happen. They just go off and
I have been bitten by that. And if I have a witness that we don't know if they're going to show up or not, we want them to be there, but then I will say in opening, I hope we're going to hear, I think we're going to hear from, not 100% sure, but you always
gotta give
deliver
what you promise.
Right, always.
You gotta deliver what you promise.
I want to quote very good friend of both of ours.
Yes.
Probably the best lawyer I know, Nick Rowley.
Nick Rowley.
Nick and I were talking when I saw a video of his, a trial he did, a med-mal trial he did in Iowa. Mm-hmm. And I said, one thing that stuck out to me, Nick, was your use of not talking. Your use of pauses to a point of almost discomfort. Yeah. And he said, me learning how to use dead space has been one of the biggest advantages. Wow. And I could not agree more. Mm-hmm. Right? Mm-hmm. I could not agree more. Right? Asking, you billed for a 1-hour conversation with a lawyer. Do you remember any of it? Nothing. Nothing. I don't remember, counsel.
You're so right. I love it.
Nothing. Right? You're like...
Yeah, that's perfect.
Right?
It's perfect. It's perfect.
Not to be overly dramatic, but that is what persuasive discussion, that's what persuasive argument and pauses are, right? That's very true. How many Obama speeches, JFK speech, ML, every major person that we think is an orator that we want to emulate.
Yes.
Right?
Yes.
Uses pauses.
Yes.
Every single one.
So true.
And so
I'm glad you reminded me of that. That is so true. Right? That is so true. I want to share with you one time. Everybody remembers the tragedy of Whitney Houston, right? That she drowned in this bathtub. And we all know the story about Bobby, and then their daughter, Bobby Christina, almost 2 years to the day after her mother died, was found in a bathtub, right? She didn't die. She died some months later. Oh, so fast forward. The prosecutor never brought charges against the boyfriend. Fast forward this. And the crime scene was sloppy. They assumed that she was a drug addict. A young black woman, drug addict in a metro area in Atlanta. They didn't really investigate. And so the guardian ad litem that was appointed to her, because Bobby and Whitney's mothers know, I'm not divulging any confidences, it was public that they couldn't get along. So the court appointed this amazing woman, Bedelia Hargrove. And then I was on the team that did the civil case, right? And the theme was, going back to the whole thing about themes, I thought about this story, is that in my closing, I said, I stand to speak for a young woman who cannot speak for herself. Mm-hmm. And we were able, obviously this burden of proof is different in a civil case, we were able to prove that the boyfriend killed her in that case and got a $33.5 million judgment in that case, right? Against the boyfriend. But he had a big book deal, he had this deal, he had a movie deal, and so any money that he ever got, But the point was that the theme was consistently, I must stand and raise my voice for a young woman who cannot raise her voice for herself. And so later, the judge said to the lead counsel, who's a very good friend of mine, David Ware, came to me right after Kira died, said, Glenda, all I need you to do is come in and do the closing. That's all I need you to do. I said, David, I just can't right now. He said, I'll wait. So after I got my legs back under me, after Kira died, I did do it. And the judge later said, Mr. Ware, whose idea was it to have judge do the closing? David said it was mine. He said there's nobody who could have framed it. And what I want to tell lawyers is that you got to make the situation has to have a human face. You've got to put a human face. If somebody died, somebody is permanently injured severely, it's not just the number of the verdict or what you're asking for. It is their life. It is what has changed in their life. You have got to make them real. You've got to be a good storyteller.
And then just another, and I mean to interrupt, but
no,
that
please.
reminds me
it's conversation, yeah.
of another lesson that Nick taught me and that I teach others. Mm-hmm. You have to meet your clients. You have to go to their home.
Oh my God.
You have to eat with them.
Yes.
You have to look through their family photo albums.
Yes.
You have to ask them to trust you, to pull out their phone right now and let's go through and remind them that their daughter, teenagers take photos, videos of events, right? The 60-year-old doesn't have any videos of the parties and the events, but their younger kids do, right?
Yes.
And having that relationship, I remember just a case that we came into, and a wrongful death case. Mm-hmm. And okay, Mike, it's ready to be tried, right? I'm like, I got to go meet the clients, right?
Right.
So we go to their home.
Gotta see them.
Right. Establish a bond. And they said something, and I'm like, man, I wish we had a video. And he pulls out his phone, and he has it. And I'm like, well, didn't you give all this to prior counsel? He goes, they've never asked me.
They didn't ask.
Right away, I'm like, let's spend the time for you to download everything.
So we can see.
Right. And then I didn't even hesitate. Even though it was past discovery cutoff, I said, dump on the defendant. Here's everything we're adding to our exhibit list. I'm planning on using it trial, et cetera, because you know that while you got to follow the rules, at bottom, most judges rule on, was it fair to both sides?
Yeah.
Right?
Right, true.
Right?
True.
You know, well, I know we didn't give it to them 32 days, but we gave it to 31 days. Well, technically, that was a day late. I'm like, but they're not prejudiced in any way.
They're not prejudiced. They're not prejudiced. Right? Yes.
And so I think that's exactly what you knew, that family. You felt that person, so you could communicate on their behalf.
Yes, and we all know Bobby as a entertainer.
And by Bobby, just Bobby Brown.
Bobby Brown. Bobby Brown was married to Whitney
Houston.
They had a daughter, Bobby Christina, who then, tragically was in the bathtub. Well, what people didn't know, Bobby was actually represented by somebody else, but he then came up and he hugged me. He said, you know my daughter. You know my daughter. But what I found out is that after her mother died, she never got back in a bathtub.
Well, that makes perfect sense.
Right?
Right?
If your mother drowned in a bathtub, would you get back in the bathtub?
0% chance of that
0%.
happening. That's post-traumatic stress.
Yes.
That causes so much emotional distress. Why would anyone do that?
Right. And so I told that story. We were careful to have two of her good friends testify, but I told that story in closing. I said, this is a young girl who is still her mother's not been dead for 2 years. And what he did basically is that he beat her and then put her in the bath. That's a whole nother story. But my point is that until you can make that person real and not just somebody they've read about being a drug addict and, oh, well, she just got in the bathtub and she was drugged out and she just slumped down. No. She never got in the bathtub. And so the only way you know that is that you spend time with the family. To your point, you spend time with people. One quick story to your point about videos. A young woman was killed in Atlanta, horrible situation. And I found the last picture of a selfie that she took in her last phone conversation with her mother. Do you not think I used that in mediation? I said, this is the last time she and her mother were FaceTiming. This is the last conversation they had. If I had not done what you just said and spent hours with this family, just, because they had to trust me. They had to see me as someone who saw this as more than a case number.
Have you looked through your client's social media? Not just for what happened since the accident or incident, but have you gone back and looked at the social media, right? I have found so many amazing videos and photos, and there's a date right on there, so you don't even need to know, so many amazing historical things that the client's even forgotten about.
Yes.
And you talk to them and they're like, oh my God, I completely
that.
forgot. My dad traveled, 2 days to get to that sporting event, whatever. As opposed to, does your dad come to your sporting event? Sometimes yes.
Yes.
Right?
Yes.
But that takes work. It
takes a lot of work.
And it also takes some emotional willingness or a willingness to be vulnerable to feeling those emotions.
And to that mother who had lost that daughter in that tragic accident, it wasn't so much an accident, but that's another story. She died, her daughter died exactly a year and a day to when Kira had died the year before. And so vastly different circumstances, but there was a certain connection, and you gotta let yourself go there. If you're going to be effective with your client, we're lawyers, but we're also human, and you've got to be willing. But it does take a toll. It does. If you're doing it right, it does take a toll, but that's the price we pay.
And so I'm being a good trial lawyer here.
Yes.
I'm trying to listen to my own instructions.
Yes.
Right?
Okay.
You as a lawyer, you know your case.
Right.
Your clients know your case. Right. You
Right.
know the story of your friends. But the people listening don't know. So you've mentioned Kira a few times.
Oh, I'm sorry.
No.
Yes.
Look, it's something that
It comes naturally.
It comes naturally.
Yes, it does.
And I always tell lawyers, I'm like, look, you're talking about Bill did this and Mr. Harris did this and whatever. And it was at the time of the incident. And the jurors don't remember the time of the incident.
Right.
So when you say at the time of the incident, which again was on such and such a date,
right.
Mr. Harris did, again, Mr. Harris was the father of the...
Right.
So you mentioned Kira.
Yes.
So Kira, your beautiful, amazing daughter-in-law.
Yes.
Right? Your son Charles's wife.
Yes.
Who died from medical malpractice in childbirth. And your son and you has done just...
But mostly Charles.
Charles has
I've been supportive of him, but
and that's how we met,
amazing.
really, through Charles.
Yes.
With Nick and Courtney Rowley's help, and Gina and I have helped as well. But really, Charles has been the overwhelming advocate who's changed
so much
healthcare around the country for women giving birth, but in general, what an amazing thing. But you mentioned Kira because obviously so important, a touchstone point in your life, right?
It's interesting you say that too, Mike, because I find myself thinking of stuff before Kira and after Kira.
Of course.
The trials, the case that I took on in Minnesota of the police officer who killed Philando Castile. Kira had died in April. He died in July. I didn't think I had the wherewithal to do it. And it was Charles, my son Charles, who said, Mom, they need you. And he actually flew with me to meet Philando's mother, and she basically adopted him as her son. But what happens is that, to your point about the empathy and the connection, the first day I walked into her home, I said, I am so sorry that your son died. I never said that again after that day, Mike. What I then said is that I saw her son as my son. Her son was literally this age right between Charles and my son Christopher. And when I started thinking of her son as we in a community needed to think of him as our son, that defined the conversation of everything that happened in that case. That we can't be sympathetic for her because it could have been your son. Could have been my son. And so that framed my conversation. And to this day, she and I, Valerie and I, still are connected because she became more than a client. And when I went in to that morgue and saw his body ripped with hollow point bullets, I mean, just torn apart, I had to understand that my job was to advocate not just for her son, but for a whole lot of sons and daughters in this country.
And I'd like to end with just that last point, because it dovetails to what maybe some people have watched me in other things. And Gina and I, we talked about billboard lawyers and mill lawyers and how they treat clients as widgets. And somebody responded to me, well, but they got a good settlement. No. And I'm like, no. You don't understand. If you treat clients like widgets, everything that you just saw, that power, that ability to transform a conversation and a jury and get full compensation, right? Full payback, you lose unless you treat them exactly opposite than a widget, right? And so if the only people a client talks to are non-lawyers and they don't even know who the lawyer is other than the name on the billboard, right? How can that firm and that lawyer represent that person effectively?
They can't.
Yeah, they could settle a $15,000, they can settle a $100,000 case for $15,000, right?
Right.
But if it's anything substantive, how can they represent?
They can't. And I'll tell you a quick story. I had a mentee who worked for one of those kinds of firms, and he said, Judge, I had to stop because I would get authorization, say hypothetically $400,000, and I would be told to offer 10, and they'll say, well, if you'll settle, and then he'll say, if you settle this by close of business today, I can give you 20. And he said, I couldn't do it anymore because I knew if I was authorized to do 100, I know that case was worth several $100,000s. And what happens is it just becomes a cookie cutter warehouse. Those people have no idea really who these people are. They don't know what they've gone through. The clients, what you take pride in, what I take pride in, is that we know the people. We can look them in the eye and say, we're doing the best we can for you. And you can't do that unless you're willing to invest the time.
Totally agree.
You can't send a paralegal out to do that. You have got to go. One quick story. I have a toddler, 23 months old child who died in Tampa, Florida. And I went to Tampa, public housing, and people were like, well, Judge, I don't know. I'm like, yeah, I'm going. Went in, sat at their kitchen table, talked to them. They have 5 other children. I know every child by name. I walked through everything, and I had to look them in the eye and tell them also, truthfully, I don't blow smoke. I'll tell you what the warts are in this case. I'll say, now listen, these are the problems that we have, blah, 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 blah. This is the upside. I always tell them the truth. I know too many people who will sell them a bill of goods to get a case. Oh. Come on, Mike. You know what I'm talking about.
So-and-so who referred me told me my case is worth, you name it.
Right.
I've heard it. Yes. We have.
And then you have to be the one. And if they walk out of your office, so be it. But I would rather them walk out of my office because I was truthful than to say to them something that I cannot deliver on. What I will say is I think that this is what we can do. I rarely say what I think a case is worth because it's initial conversation. You just don't know. But I have had lawyers say, well, I can get you. Oh, wait, let me,
Oh, Mike, I didn't tell them that. I said their case could be worth between $1 million and $10 million. And they're saying $10 million. I'm like, first of all, a client never hears anything.
They don't hear the one.
They hear the highest number.
They're going to hear the 10.
And an insurance carrier only hears the lowest number.
Right.
Always.
Always.
So don't use those numbers.
I know. Don't use those numbers.
Anyway.
And tell them the truth. Tell them the truth.
Of course.
Tell them the truth.
So how amazing. Thank you so much.
Thank you.
I could talk to you forever.
I learned so much from you.
So thank you for being here. And I know
I love being
you're
here.
here filming, I think.
Yes, here taping the
for
show.
your show.
For
And
court show.
wonderful to have you. Thank you so much.
I love being here. I hope we'll do it again.
That's a wrap.